So, it is now my pleasure to introduce our first speaker. We do have a slight change in the advertised programme. Gary Bourne of WilmerHale was due to be our first speaker, but unfortunately late last week he was called on a hearing to Brazil and isn't in Brazil and wasn't able to join us today. But happily, Gary's partner at WilmerHale, Stephen Finizio, has stepped into the breach. Stephen is a member of Wilmer, Cutler, Pickering and Hale and Doors, LLP's International Arbitration and Dispute Resolution Group, based in London. He advises clients regarding disputes under the rules of the most well-recognized international arbitral institutions and governed by the laws of jurisdictions in Europe, Asia, Africa and the US, as well as disputes under bilateral and regional treaties. Steve's recent publications include gas supply transactions and disputes, energy arbitration in Africa, destination restrictions and diversions in LNG sale and purchase agreements, and enforcing arbitral awards in sub-Saharan Africa. We are therefore in very safe hands indeed, as Steve delivers the intriguingly entitled Is Winter Here?, which I'm told is not a reference to the weather. So please help me welcome Steve to the stage.
Thank you, Brandon. I apologize on behalf of Gary, who really did want to be here. And as Brandon said, he had such an intriguingly titled presentation that I felt like I couldn't do something different. So I sat with him to talk through what he was going to say. And when we begin conferences, we usually are celebrating a bit and we're looking forward in positive ways. This is gloomy, as the title suggests, and it is a weather forecast to some degree, or worse than a weather forecast. It's even gloomier. Winter is here, is the suggestion. So what does it mean? And I think the points he wanted to make are things that will be familiar to enough to many of the people in the room, but I think they're important points, so I thought it was worth taking the time to convey some of them and to talk about what they mean, and then to talk about what they mean in particular in the context of a conference about energy and Africa and the Middle East, where I think some of these issues are even more pointed on particular concern. And I say that in part because if you want to extend the metaphor, I think in the Middle East and in Africa, what we're seeing is not winter at the moment, but we're seeing spring. So what does it mean for a leading arbitration lawyer like Gary, the president of SEAC, to talk about winter in the context of a conference where we're talking about regions where we think we're seeing spring? So I wanted to talk about that and to talk about whether, if he's right, that winter is either coming or winter is here, what it might do to kill the shoots, the green shoots of spring that we're seeing in the region. So that's what I'm hoping to do today, and hopefully I won't torture the metaphor too much. Winter, and this is in Gary's words, follows summer. And he would say we've had a long, productive, even golden summer during which international arbitration has flourished for the last 30 or 40 years. And when we see that summer, that flourishing, in a number of ways. Some of them are quite obvious. We see this in caseloads, arbitration caseloads, and the growth of arbitration institutions. Gary's institution, SEAC, I will talk about it a little bit because I think SEAC is in some ways one of the great examples of the growth of international arbitration, both regionally and globally. But if you look at simple caseload numbers, and you look at it over a period of 30, 40 years, it's relatively remarkable to see what's been happening. You see the growth across institutions, whether they're institutions, major institutions like the ICC, where the numbers have gone from the early 90s or the mid 90s, from things like 350 cases a year to now looking at 800, 900 cases a year. Institutions like the LCIA, which, despite its importance in this market, was bumbling along with 20 or 30 cases a year 20 or 30 years ago, and now we're seeing 300 cases a year. You see that in frankly, the complete creation and growth of the institution like SEAC, which had really no cases or a handful of cases in the 90s, and now you're seeing numbers in the range of 200-300 cases a year and growing rapidly. You're seeing that in regional institutions, where you're seeing institutions be founded, but also cases starting to develop, so there are real caseloads. And you're seeing it, of course, in treaty arbitration. And if you think about the growth of cases at ICSID, in the early 2000s, there had been 70 cases ever, and I think 17 had gotten past a jurisdictional stage or had been taken forward. And now we're seeing, as the recent years show, 40, 60, 70 cases a year, at least at ICSID. So we're seeing growth. This is the summertime. And it's not just in those established, well-known institutions. We're seeing the founding of institutions. And we're seeing in particular, we see this in Africa. We're seeing now a number of institutions in Nigeria. We're seeing institutions in Kenya, and the Nairobi Center. We're seeing it in Rwanda. We're seeing it in Cote d'Ivoire. We're seeing it all over sub-Saharan Africa. We're seeing a real interest in founding institutions. And for the first time, I think, real communications between the institutions to say, how do we develop this thing that we want to develop? And a real cooperation. So we're seeing that in places in Africa, more established, but maybe less competitive in North Africa. We're seeing it in the Gulf and in the Middle East, including with some institutions that are closely affiliated with some of the major institutions, DIFC, LCIA. We're seeing things, we'll see how it develops, but we're seeing the LCIA MIAC and the effort to create Mauritius as an arbitration center. We can debate where that's going, what that's going to be, and how relevant that is to Africa. But we're seeing this interest. So this is part of the summertime, and I think we all know that, and that's what we're here in some ways to talk about. We're also, in important ways, when we talk about the growth of the summertime of arbitration, we're talking about issues like arbitrability, where we've seen a real growth, not just in caseloads, but the subject matters that are being arbitrated. We're seeing, between courts and legislation, we're seeing a wider range of issues being subject to arbitration. We're seeing it even in places that are more reluctant, like in the recent Russian reforms, where there's been an effort to some point, we can criticize it, but to grow the amount of corporate disputes that are subject to arbitration. We're seeing, we know typical examples like allowing antitrust or competition law claims to be arbitrated, some tax issues to be arbitrated. We're seeing it in use, though. We're seeing it in the growth of use by financial institutions. We're seeing it in the growth of IP disputes being subject to arbitration. So that's another part of the growth, the positive side of what's happened with arbitration in the last 30 and 40 years. Why? What's generated this long golden summer that we've seen in the last 30 or 40 years? Well, the obvious answer, and sometimes one that we overlook, but the obvious answer is this has all happened in the wake of the New York Convention. And so I think it's hard not to say that the New York Convention has been a remarkable success story. We're now at the point where I don't even bother to count because it changes daily, but we're about 160 countries that have ratified the New York Convention. There's one or two every few months that are still joining. It's now become a truly global convention. I mean, the number, 160 countries, makes it sound global, but we have to remember that this was not the world 30 or 40 years ago. And even if you go back to the early days, it took a fair amount of time for some of the major trading states to first ratify and start to implement the New York Convention. You're talking about the United States, 1970. This is a recent phenomenon, but it has gained a huge amount of momentum. And perhaps in part it's gained momentum, and this is one of the points I think that Gary wanted to make as we look forward. It's gained momentum in part because it's drafted in relatively brief, simple, and very broad terms that have left, those terms leave a lot of leeway to national courts who have developed around the principles of the New York Convention a very robust and effective set of interpretations of the convention and application of the convention through interpretation of local laws and application of local laws that really have made international arbitration agreements enforceable around the world and have made international arbitration awards enforceable around the world. And so why? Why has the New York Convention been so successful? It's been successful in part because of the way it was drafted and the approach it took. But it also, I think, has been successful because it provides something that is good for commercial interests, it's good for trade flows, it's good for courts, in fact, and more fundamentally, one of the reasons we should celebrate it is that it's good for the rule of law. What drives that, and how did it actually come to be that this good thing was put into action? Well, I think the answer is a real public-private partnership between, on the one hand, businesses and the legal profession that were both very motivated to come up with the most efficient, the most sensible, and most neutral means for dispute resolution, particularly with cross-border transactions and investments. And on the other side of this partnership, as part of this partnership, critical support has come from legislatures, including through the implementation of laws supportive of international arbitration, including obviously the very significant impact of the UNCITRAL model law, which has been hugely influential, even where it hasn't been adopted and has been adopted in many places. And just as important, or maybe even more important, has been support from courts, starting in major jurisdictions. And again, we sit here today in 2017 and we take a lot of this for granted, but critical decisions were taking place in the US in the 70s, in France, in the UK, in countries that were critical to creating the groundswell and foundation for support that have then been mirrored in other countries. Now we're seeing critical decisions being made in India and in China, frankly. The support of the courts is critical to the development of international arbitration, and all of that has made this past 30 or 40 years a really exceptional time for international arbitration. And you see pieces of this happening right now in the Middle East and Africa, including in particular sub-Saharan Africa. You see modern arbitration laws being adopted across the Gulf and the Middle East in the last few years. Saudi Arabia, a notable example very recently. You see innovations. You see the creation of free trade zones, trying to develop the use of international arbitration further and encourage investment. You see developments in Africa. Sub-Saharan Africa is slower. We have a big issue about the uptake of the New York Convention, but we're seeing interest and desire to implement the New York Convention. You see increasing modernization of arbitration laws. We're waiting, hopefully in the next couple of months, to see a new arbitration law in South Africa. You see the effect of OHADA. You see real interest in moving forward in those regions. Courts are harder to talk about in the Middle East and in Africa, in part because lack of availability of court decisions, but you see interest in the private side and the academic side to figure out how to make court decisions more readily available in those regions. Both there's language issues, but there's publication issues, there's access issues, all very important to developing a familiarity and a comfort with arbitration, and those things are happening, and there's a lot of interest in developing that, particularly by the legal profession. I said earlier, Gary's institution, SIAC, and what has happened in Asia is a model for Africa and the Middle East. We see the explosion of arbitration in Asia, and a jurisdiction like Singapore has obviously become a model that lots of other jurisdictions are aspiring to, whether it's Morocco, whether it's Mauritius, other places, Hong Kong. There's competition. Competition is good. It fosters people wanting to develop and improve and to get state-of-the-art laws and state-of-the-art practices. So these are all positive signs. I've just described summer. These are signs of growth. So why am I talking, and why was Gary talking about winter, not just coming, but winter being here? And let's start with the easiest signs of chill, of coldness that we see. And that's, I think, in the very active criticisms we're seeing of investment treaty arbitration. And I will briefly mention some of the loudest criticisms we hear of treaty arbitration. And it's worth bearing in mind, as I mention these, that we may separate out or think in terms of differences between treaty arbitration and commercial arbitration, but that's not how the world sees it. That's not how legislatures see it. That's not how politicians see it. That's not how the public sees it. So the criticisms that we hear of treaty arbitration inevitably affect commercial arbitration. So, and what are some of the loudest criticisms? Well, one of the ones we all know is this issue of transparency and the notion that treaty arbitration creates secret tribunals representing corporate interests that are deciding critical public issues relating to governments. In some ways, it's a puzzling criticism at a point where we are also seeing really significant efforts to make treaty arbitration more transparent through amendments to treaties, amendments to NAFTA, amendments to ICSID, the Mauritius Convention, the UNCITRAL transparency rules, various things. We see treaty arbitrations being webcast live. We see the availability of decisions both through the UNCITRAL transparency rules and the depository where you can find decisions there. The ICSID website is a fantastic resource, right? Telling you what's going on in all these cases. And this is something that is within the control of states. If there really is a desire by states to increase transparency, they can do it. They can amend their BITs. They can put more transparency requirements into new BITs, into new trade agreements. Some states are more interested than others in doing that for good reasons, but we hear this as a fundamental criticism, secret tribunals, when in fact the steps are being taken in a very positive way, and more solutions are available if the will is there to fix those issues, if we conclude that they really are issues. We also see criticisms of diverse decisions on related issues, fair and equitable treatment being defined one way, or questions about whether a cooling off period is substantive or procedural, and the criticism is this is just ad hoc, it's a mess, there's no principle here. And I think you take a step back and you say, well, what you have is transparency. You have published decisions that in a growing area where there's still really a handful of key decisions, of course we're going to see differences. But those differences create an opportunity for discussion and, over time, harmonization. But it becomes used as a fundamental attack that says the whole process is illegitimate, which then transfers or is fueled by the notion that this is a biased process. And I think the basic criticism is that investment arbitration is tilted, and maybe that's too light a word, tilted against the host state, and that what it's doing is it's a system designed to protect commercial interests, to protect investors. And of course, it's hard to show empirically what's really happening, but all the empirical studies we see say this isn't the case. What we're seeing is a third of the cases being decided in favor of states, a third of the cases being decided in favor of investors, usually though not getting anything like what they've asked for, and a third of the cases being resolved by settlement, which all suggests a system that actually works. But the perception and the criticism is that this is a pro-investor, anti-state process. So these are the criticisms that then turn into sort of uglier issues when you start talking about arbitrator bias. And I think everyone starts to fall into this habit of talking about pro-state arbitrators, pro-investor arbitrators, arbitrators from corporate backgrounds, corporate law firms, and the notion that we come back to our secret tribunals. And we end up in a system where the arbitrators are questioned, their independence and impartiality is questioned, challenges become the rule rather than the exception, challenges are publicized, and the impression that the public takes away is that you've got a system that allows for biased arbitrators and protects against any effort to prevent biased arbitrators. And all of this not only undermines confidence in treaty arbitration, but it's the same process, and so it inevitably undermines confidence in all forms of international arbitration. And where do those criticisms take us, and what motivates them? And let me come back then to Gary's winter. Gary's point is that those who would tear down the system of investment arbitration actually do international law, and therefore the world we live in, we all, not just the people in this room, but that we all live in, but particularly the people in this room, a huge disservice. And the question is not, are there things we can improve, and is arbitration perfect? But what would the critics of arbitration, what world do they want to see? And what would the world look like without a neutral and independent application of legal rules that is the benefit we get out of international arbitration? What alternatives stand behind the criticisms? And the answer seems to be returning power to governments or to states or to things that look an awful lot like transnational government institutions. You see that, for example, in the proposal in TTIP to create an international investment court rather than use arbitration. And we also see that in things like proposals from very serious international lawyers and arbitrators to eliminate party appointment of arbitrators and to create a process where arbitrators are all appointed by institutions. We see that in notions of regulating arbitrator or counsel conduct and suggestions, for example, that we have a transnational group that would regulate the conduct of counsel or representatives in international arbitration. So this notion seems to be that we would be better off with some sort of centralized state-like or court-like process. And we see that not just coming from people involved in arbitration, but we see that coming from really eminent jurists. We see the Lord Chief Justice Thomas essentially arguing that arbitration interferes with the development of the common law, and that arbitration and arbitration awards need to be subject to increased judicial scrutiny. We see that also in some of the criticisms that Sundaresh Menon makes, the Chief Justice in Singapore. And so you see a suggestion that arbitration needs to be regulated more, arbitration needs to be subject more to state court control. In other words, that arbitration needs to be renationalized. And it begs a lot of questions about what we want to do with arbitration. Do we want arbitration to resolve disputes, or do we want arbitration to make law? And it raises questions about what is it that people use arbitration for? They use arbitration for consensual dispute resolution. They choose, commercial parties choose international arbitration for good reasons. They view it as something that provides neutrality. It avoids the lack of familiarity with the process of going to a state court or a process in a foreign country. They obviously value its enforceability. They value its finality. They value three-member tribunals where they can appoint co-arbitrators and have a say in who the presiding arbitrator is. And they value not being subjected to a state court judge in another country. These are things that users value. These are things that foster the growth of the rule of law, particularly with regard to international transactions. And these are things that calls for increased scrutiny by state courts or the creation of more transnational institutions to regulate arbitration are fundamentally inconsistent with. And Gary would take it further, and the reason why the title might sound a bit hyperbolic, but he would take it further and say, if you take a step back and look at the roots of these sorts of criticisms, what do they remind you of? They remind you of, first of all, criticisms from people like Joseph Story, who critiqued arbitration as being a form of rough justice administered by men, and I think he meant men then, not people. Today we would say people, who aren't really lawyers or can't really be trusted to apply law the way a court judge could apply law. And if you go further, you see it, and Gary would say you would note it in things like what happened with Napoleon. And when you talk about golden summers, the Constitution year one of the French Republic after the Revolution, one of the constitutional rights that was guaranteed was the right to arbitrate. And it was intimately tied up with the general right of citizens to control their lives, of basic human rights. And one of the first things that Napoleon did was to say, I don't like that. I don't want to give people freedom to decide their own relationships and decide how to resolve their disputes. And so the Napoleonic Code and subsequent years did away with that and created a world where state court judges, state judges, the state would resolve disputes, would control relationships. And it's interesting, and again, maybe you could call it hyperbolic, but if you look at what happened in the 1930s in Germany, when the National Socialists came into power, there was a robust arbitration culture in Germany up to that point, and the Nazis adopted guidelines on arbitral tribunals that said, among other things, state interests can't be arbitrated, and they did everything they could to discourage the use of arbitration for private dispute resolution, in part because it was inconsistent with and threatened state control and authority. And they didn't like it. So that's the winter. And I could go on and be bleaker and talk about some other regimes in place right now, but that's the winter. A vision of the world in which the state or some form of state entity is responsible for everything. And that really is antithetical to what international law has taught us over the last 30 or 40 years. We've seen that arbitration furthers the rule of law in international transactions and investments, and it furthers the rule of international law. And the instinct that taking that away and regulating it is one that does really raise significant concerns. Now, Gary would stop right now. My talk is much less colorful. He has Games of Thrones analogies that he wanted to make, and I don't watch it, so I couldn't do it. He had zombies. But he would stop now and he'd say, we as an arbitration community are being hunted, and we're too defensive, and we need to stop being hunted, and we need to start to hunt. And I want to be less dramatic, but I do want to come back to Africa and the Middle East and note that it really is a spring. I've spent a lot of time in sub-Saharan Africa, and it really is a spring. There really is a desire and interest and active activity to growing arbitration in that region. It gets a lot of attention. There's a lot of motivation. Some of the attention is critical, but it's healthy criticism. It's recognizing that arbitration can bring a lot of good, both in terms of encouraging investments, encouraging the rule of law, developing the legal communities, developing institutions, dealing with issues of corruption. There's lots of good that people see in arbitration. As I said, some of the attention is critical. The question gets asked, why do we see in treaty cases 2% of the arbitrators appointed are from sub-Saharan Africa, 5% overall are from the Middle East and Africa, and if you break that down, it's 2 or 3 people, an Egyptian, a few South Africans. I mean, there are reasons to be critical of that situation, when you come from that part of the world. And to say, why is it that when energy companies want to arbitrate or dispute about an energy project in Africa, they're doing it in London? Why aren't we doing this in Lagos? You know, these are serious questions, and there's a serious desire to change that by legitimizing arbitration in Africa and developing the institutions and the experience of the lawyers there and the courts to say, we are good enough to have it here. We're keeping cases that involve us here. That's a critical but healthy view of arbitration. But influential people in those places, they're watching the legislatures, the judiciaries, the ministries, the politicians. They hear the criticisms. They hear that arbitrators are biased, and it fuels perceptions they already have. They question why they're members of ICSID. They question why they're signing bits or signing bits that provide for arbitration. When, for example, Europe is saying we don't want arbitration when we have a trade agreement with the US, African states say, well, why should we have arbitration? And there may be answers, but they're fair questions. And when you see that, the question you get in sub-Saharan Africa is this a colonial process? Are we being asked to do what our colonial, I don't know the right word for it, but our colonial forebears want us to do? Should we just adopt the New York Convention or the Institutional Model Law, or should we localize it? Should we introduce into it review rights or things that recognize our legal systems or our legal concerns? Should we recognize and have a greater role for Sharia law in the way we review arbitration awards and the procedures? These are legitimate questions, but they're also influenced by watching the criticisms that are taking place of treaty arbitration and of arbitration more generally. And where does that leave us? Parties, private parties, individuals, many of the people in this room, they want to resolve their cross-border disputes through arbitration. But we're left with a world where if those springs, those shoots of spring that we're seeing in the Middle East and Africa are frozen, we're going to see international energy companies continuing to insist, for example, on arbitrating African disputes in London, not in Lagos, or not in Saudi Arabia. It's going to leave parties that have contracts that lead to disputes in the Gulf or the Middle East assume that they're not really going to be able to enforce an arbitration award there. They don't want to go to the courts, but they're not going to enforce an arbitration award, so they're going to discount the value of their contracts and assume that they will not be enforced or enforceable their rights. And it leaves lawyers and arbitral institutions in those places who see our arbitration as a way to develop the rule of law and to encourage trade flows and investment cut off just as they're being started. So I think that's where I'll stop. I'm not sure whether Gary's right that winter is here, but he's right that we can't be complacent and that we can't assume that there will be an endless summer. We need to think about these cold winds, and they are cold winds, and we recognize a lot of these. And we need to think about what those are doing to the spring that we're seeing in places where with the right sunshine, we may see really important positive developments. And so while this is meant to be a celebration and I've been gloomy, I'll stop on that. We have the ability to keep the sunshine, but we've got to work on it. We can't take it for granted. Maybe we don't need to hunt, but we cannot be complacent. So I'll stop there. Thank you.
Spring always follows winter, doesn't it? So these things go in cycles. So thank you very much. And we now move on to our second keynote speaker of the morning, who is Craig Tievendale from Herbert Smith Freehills. Like me, Craig is from Scotland, so that's good. He is, offering my professional opinion, he's head of Herbert Smith Freehills International Arbitration Group in London. He's fluent in Arabic and French, and he is frequently instructed in disputes arising from investments, projects, and transactions in Africa and the Middle East, including Iran. He's regularly published on issues relating to private international law, arbitration and energy disputes, and lectures on energy law at University of London. He has also been appointed in expert determination proceedings as an expert in English law. Craig is going to address us on the Egyptian paradigm, energy success and failure in MENA. So please help me welcome Craig to the stage.
Well, good morning, everyone. And I'm delighted to join you today to talk about a jurisdiction which has a very considerable significance to the energy sector in the Middle East and North Africa, and that's Egypt. You may be thinking, well, hang on, isn't this supposed to be a keynote speech? Isn't that a little bit too specific? Well, I'll leave you to decide. But my hypothesis is that Egypt's experience will tell us something more broadly about dispute resolution in energy in the region. Because some things are done well, some things are done haphazardly, and some things are not done at all. And from those experiences, we might see there's some interesting lessons to learn about what works and what doesn't, specifically in North Africa, but I suggest more broadly in the region. So we'll look at the context without making it a history lecture. We'll look at 3 case studies to draw out the themes that I want to talk about. We'll look at the future, then we'll have some conclusions. But we'll start with some history, context, and background, because it's only possible to understand what's happening in energy dispute resolution in Egypt by reference to what has been happening over the past 10 to 15 years, and more specifically, the last 6 years since the 25th January revolution, as the 2011 revolution is often known in Egypt. And as you'll recall, President Mubarak was ousted from power in early February, late January 2011, and you'll all probably recall those incredible pictures from Tahrir Square and what happened immediately afterwards. And if you'll indulge me briefly on this, I enjoyed 40 well-spent, they're always very well-spent minutes in the Egyptian Museum in Cairo on my last trip a few weeks ago. One lunchtime, it was lunchtime, I shouldn't have been working, so it was all fair enough. If you've had the good fortune to visit Egypt, you'll know that the museum is right next to Tahrir Square, the main focus point for the protests and the police crackdown. And one exhibit really brought home to me the chaotic impact on Egypt of what happened in 2011. If we can... there we go. Oh, no, we don't. There you go. So on the left, this is the before. You see a beautiful statue from Tutankhamun's tomb. This is the goddess Menkaret holding up the boy king. But on the right, if it'll come up a little quicker, there you go. You'll see what happened after, what was recovered later, following the return of various looted and vandalized items to the museum. You can see poor Menkaret has lost the king and a good few other things besides. The statue is much diminished in the after picture, rather like the quality of my photography. But really, the point that made a strong impression on me at the time was that here was a beautiful object that had lasted nearly 3,500 years. But it didn't survive the tumult of the 2011 revolution. And to me, that's an apt shorthand of the impact of what was happening in these tumultuous years on Egyptian society and also in the economy. So there was lots of change. Lots of change, and amongst that, there was a major review of economic transactions in President Mubarak's rule. Some were reviewed, some were nullified. You can look on that in different ways. It's impossible to generalize completely. Some would characterize some of what happened as setting aside illegitimate transactions. Others would say, well, there was an element of settling scores as well. There's a range of different views, but what is clear is that much of what happened impacted upon investments that benefited from investment protection. And the outcome of that, whether you agree politically with what happened, is that you have a wave of investment treaty cases and commercial arbitration cases around investments coming out of that. So there was a period of instability and economic turbulence. President Morsi from the Muslim Brotherhood followed, but not for long. That was a very unpopular rule. He was displaced by President Sisi with 97% of the vote around in June 2014. And 3 years in, again, I'm not a political commentator, but based on what I see and the clients I speak to, others that I speak to in the jurisdiction, it does appear that President Sisi retains a pretty strong popular mandate. He's made a number of important changes which are significant, whether you agree with them or not, when we consider energy arbitration. And all of this against a backdrop of a growing population. A third of the population of Egypt is aged under 14. That's a very big demographic to see coming along for the next generation. Energy shortages, power cuts, and the government often has to choose between supplying industry with power or supplying the domestic consumer, and that's tricky. 65% of Egypt's gas is burnt for electricity generation, and that's a huge proportion. There's a massive issue around fuel subsidies. Egypt is estimated to have spent, since 2011, on fuel subsidies around $90 billion, which is an extraordinary amount of money for any jurisdiction. In Egypt, that's a very significant sum. That's around 20% of the state budget year on year over that period, and that makes a big difference. So IMF support has been contingent on challenging those fuel subsidies and reducing them. That hasn't been well received domestically, as you'd expect, because that has a very visible and immediate impact when the cost of a taxi goes up by 40% or 60% overnight. People are not very happy about that, and you can understand why. When you lay all of that over some pervasive, long-standing issues in the energy sector, particularly around the diversion of gas supply from the export market to the domestic market, when you look at the huge debts which have built up, which have been owed to IOCs, what you'll find is a very fertile ground for disputes and indeed to some extent social unrest, although it's fair to say that some of the changes that have been made under President Sisi and have been accepted, I think would have had people on the streets instantaneously had they been put under previous regimes. But things are beginning to look better economically, and the outlook generally is looking better. The Egyptian pound used to be pegged artificially to the dollar, around about 8, 9, just short of 9 Egyptian pounds to the US dollar. Inevitably, a parallel market arose for that, and that wasn't healthy. So what we've seen in recent times, in November last year, is the bold step of a free float on the promise of $12 billion of IMF support, which was duly delivered. And as the Egyptian pound stabilizes, what we should see is an increase in foreign direct investment and foreign currency, an increase in foreign currency reserves, which is going to be very good news. Don't take my word for it. Better, more informed commentators than me see this as a good thing too, if you can see the slides at the back. But there's a quote there from Christine Lagarde and another one from the Financial Times, which make that point. Now, before we get into the case studies, against that very challenging background, the Egyptian energy sector has continued to play an absolutely vital role. And disputes in various forms have continued to arise. But before I turn to look at the detail of those, I want to plant a thought in terms of how those disputes are beginning to be resolved and also avoided, which is even more important. And there's an Arabic proverb which, to my mind, is an appropriate as a theme for dispute resolution in the Egyptian energy sector. And the proverb is Yad wahida la tasaffaq. And that, if we can bring that up, it means one hand doesn't clap, one hand cannot clap. And the sense of that is that nothing can be achieved without cooperation. It's impossible to achieve meaningful results unilaterally. And that might be the real theme which runs through dispute resolution in Egypt. And it's certainly the principle that I suggest you can track strongly when you look at how the Egyptian state seeks to resolve its disputes. And many in Egypt, I'd suggest, believe that it's becoming a successful strategy. But we can look at some cases to explore that a little further. Now, the first case study is about the Israeli gas disputes, and this has become quite a high-profile series of cases because it isn't just one. It's high value, and there's also a political element to it, an incendiary political element to it in some quarters. The basic framework is that EGAS and EGPC agreed to sell gas to EMG, and that would then be supplied to Israeli customers. As part of that, EMG would transport it via a pipeline. There was a GSA between the Egyptian state entities, EMG, and the customer, Israel Electric. Now, what you need to know about this is that it was a Mubarak-era deal. It was signed in 2005. And post-Arab Spring, there were allegations that this was not okay. There were allegations that the deal had been made at a tremendous undervalue, that corrupt officials had been involved, that the gas shouldn't have been sold anyway because we're in short supply at home. So it was certainly an unpopular deal in Egypt, whether you accept that characterization of the merits or you don't. And a central theme, I think, taken against it is that the Egyptian state was doing its best to get out of an unpopular deal, and it was in breach of contract and treaty by doing so. That's the case. So from this Arab Spring dispute, what we've seen are 4 related cases with an aggregate value of $7 billion, and that's why I say that it's high profile in Egypt. That could have shown up better. I'm not sure if that's going to show up better, but I'll try to summarize it. This is the first of those 4 cases. This is the case of Ampal, American-Israeli Corporation versus Egypt, a case under the USA Egypt BIT, and at the heart of it were allegations that EGAS and EGPC had withheld deliveries effectively to prompt a renegotiation on price, and that Egypt had also failed to offer full protection and security to the pipeline because the pipelines were bombed around 14 or 15 times after 2011. It was a very unfortunate series of problems. Amongst other problems, an increasing level of terrorism in Sinai, and Al-Qaeda in the Sinai Peninsula formally declared in August 2011, which again was bad timing, although the link between that type of terrorism and saboteurs unknown remains a question of opinion in some quarters. But in any event, the decision's out on that one, and it was found that Egypt had breached the treaty by expropriating a tax exemption, which was found to be an investment rather than its own right, and by failure to maintain the FPS standards. So these cases have been very painful in outcome for the Egyptian state. There's more to come because then there was the related ICC case of Israeli Electric Corporation and EMG versus the state-owned entities. The finding in that was $2 billion of damages across both claimants. The Egyptian state didn't accept that. It sought to challenge immediately. It brought a challenge at the seat to try to set aside the award. But in very recent times, this month, the Swiss Federal Tribunal has upheld that award. There are 2 further cases to consider. There's an UNCI-trial PCA administered case brought by EMG's investors, and then there is also a Cairo Regional Centre claim by EMG. So there's probably more of this to come for the Egyptian state. There hasn't been much cooperation or conciliation and evidence in this saga, and there certainly hasn't been much clapping about it in the Egyptian government at the state entities. So you can characterize these cases in a few different ways, and I look at them as an observer rather than someone who's either arguing on either side or sitting on the tribunal. But when you look at it as an observer in the context of what's happened and what will happen, I look on it as perhaps the most significant example of a unilateral post-Mubarak change of direction by the Egyptian energy SOEs. And it's been a deeply unsuccessful, a deeply unsatisfactory experience for the Egyptian state. There's no question about that, whichever view you take of the rights and wrongs of it. So what are the consequences and the implications of that? Well, there's been a very direct impact on negotiations over a prospective importation of Israeli gas. And there's an interesting quote about this, which was which came out of the Israeli parliament shortly after the ICC award was issued in a parliamentary hearing. This is Yakov Peri, a member of the Knesset, and he said, "My sources are telling me the Egyptians won't do any deals with Israel if the arbitration isn't settled as they want. They all say that Israel has to intervene and cancel the arbitration." And that was after the ICC $2 billion case. It shows the political significance of gas in Egypt, for one thing, and it also shows that where Israel is involved, that the ante is yet further increased. The second thing it tells us is that Egypt will continue to be paying out damages for actions and decisions taken immediately after the Arab Spring, to the extent those cases are not successfully compromised. And there's an incentive to do so when you see what's happened here. And it's interesting, there's an interesting statistic to back this up, which is the third bullet there. The government has faced 37 international domestic cases with a docket value of 14 billion in the 3 years since 2011, which is said by an Egyptian government source to contrast with approximately 2 cases every year prior to the 25th of January revolution in the previous 27 years in which Egypt was signed up at ICSID. So, Egypt has been defending many fronts, and for that reason it's very keen to talk to investors, and particularly long-term investors. So, as the second case study, here's an example of a common issue in recent years, the diversion of gas from the export market to the domestic market, which is, of course, seriously bad news for exporters who already have long-term GSAs in place with their own customers. They may be able to declare force majeure depending on the exact actions taken by the state and the contractual protections that they have in place, or, in my experience, more often may not, and then you really do have a problem. You're looking at, well, what's your recourse against the state? So at Damietta, the state stopped natural gas supplies to the LNG plant, and the case developed in 2 stages. First, Seagas filed an ICC claim for $270 million, saying that, look, okay, you're diverting this because there's energy shortages in the domestic market, but you have to pay something whilst the production's suspended. And then there was a second claim, because that ICC claim failed, but meanwhile, Union Fenosa's parent, the parent of Seagas, filed an ICSID claim under the Spanish Egyptian BIT, and we wait to see what's going to happen with that one. But if we take stock at this point of where energy disputes sit amongst Egypt's onerous ICSID caseload and compare it to some other African states in the last 5 years, well, we see that Egypt has been busy. And let's have in mind, of course, that this table only tells you about cases registered at ICSID in this sector. It doesn't include other treaty cases pursued elsewhere, such as the UNCITRAL case brought by EMG's investors, for example. It doesn't include a number of others which are not in the public domain. You'll notice there's one in that table which I haven't talked about, National Gas, SAE, that's a UAE Egyptian dispute. It's only worth $36 million, so it doesn't earn its corn in this particular discussion. The third issue, the third case study, is a very old story. And rather than tell the full old story about it, I've decided just to use the words of one affected upstream investor, day1 Gas, without commenting on it in any real way. But look, this was a press release from 3 weeks ago when they were announcing around a condensate sale at the end of April. They said the cash proceeds of $7.2 million will be offset against our overdue receivables, which stand at $289 million. However, collections of our overdue receivables in general remain well below our expectations. We are yet to receive a significant payment this year. We continue to engage with various government entities, and we hope that the Egyptian government will resolve the situation favourably in the near future. You will note that is short on concrete points of reference, other than how much is owed. But in terms of the future, that's a rather cloudy crystal ball. So there's a great shortage of dollars in Egypt to pay outstanding debts. That's been the story. All IOCs are affected, have been affected for many years. Some feel the pain more acutely than others. And what we can observe is that dialogue, often linked to future opportunities, future exploration, future investment, license extensions and so on, is the government's preferred method of resolving this type of dispute. The SOEs do not respond well to proceedings being brought in relation to this type of dispute, and even less well to any threat of a treaty case being brought. And that is likely to put you at the back of the queue when it comes to being paid out for your overdue receivables. 289 million for Dana Gas, much, much more for the larger players. But what type of claims has that given rise to? Well, contractual claims, naturally, against EGPC and EGAS. Treaty claims, because of the diversion of gas supply, usually framed in terms of either expropriation or a breach of FET standards. And everyone is always very interested to compare their treatment and how much they're being paid and when they're being paid against others to see if there's a discriminatory treatment in terms of the financial burden imposed on others in analogous positions. As you would expect. Then interestingly, JV disputes, they've been very active in our practice the last couple of years, largely because it doesn't involve taking a position against the state, which is always helpful. And that would be issues where, cash calls under the JOA will typically be denominated in dollars. No one wants to give up their dollars. The operator, if you can insist on dollars, is very glad to have them. There might be some questions around, it would be fairer all round if you were to denominate some of this in Egyptian pounds, because that's what we're being paid. We're stuffed with Egyptian pounds and we can't get rid of them. It's not very fair that you, the operator, should hoover up all the dollars and then use those to pay what you want to do and repatriate your profits whilst using your own Egyptian dollars to pay off the local contractors. Where does that leave us? And isn't there something called the no loss, no gain principle when it comes to the operator's roles? So that's been a lively set of disputes, I would suggest. But again, there is cause for optimism, because what you can see is a clear trend towards paying down the debts. We don't need to run through all of the numbers, but if you start back in 2013 with a reliable statistic of $6.3 billion owed, again, that's not a small number, but then you look at how that has developed. Currently, we're down to 3.5 billion. By the end of the year, the intention is to reduce it further, another 20%, and take it down to $2.8 billion. You'll notice 60% in dollars and 40% in Egyptian pounds, but you can't have everything. And the stated objective is for the government to have paid out its entire debt by 2019. Now, that's an objective, and there's a healthy skepticism as to whether that will be achieved. Of course there is. There's perhaps no great expectation. But I would say, and it's a generalization again, these things always are, but there is a sense of optimism, a sense of patience, a sense that things are going in the right direction. Now is not the time to be rocking the boat with the government, or you'll find yourself at the back of the queue. And there is at least objectively far more reason to be cheerful now than there was in the dark days of 2011 and 2012, when the debt was increasing, when there was no real government focus or commitment or means, frankly, to reduce the debt, and when there was no objective basis to expect that to change. So there is a revenue stream in place for the IOCs, and that counts for a very great deal when it comes to generating investor confidence and keeping people on board and avoiding formal disputes. I won't spend long on this because I know time is marching on, but there's some further progress in the shape of some new initiatives by the government to settle the mounting docket of investor-state disputes. The Minister of Justice has set up the DSC, the Dispute Settlement Committee, which has made recommendations in respect of many of Egypt's investment disputes. Importantly, this is not only a purely government enterprise in the sense that it's drawn up of ministers or civil servants. It's also drawn from some quite eminent private practice practitioners who are able to bring a dose of realism as to what will happen if these cases are arbitrated, which is very important indeed. We begin to see the fruits of their work in the treaty docket, and we'll look at that shortly. Similarly, along similar lines, but a new settlement committee with more teeth was set up in 2015. There is a certain difficulty in ascertaining and discerning exactly where the lines between the two start and end, but nevertheless, they're both known to be doing good work, and we can see in a moment where that's coming out. So although if you like, the jurisdictional overlap may not be clear, what is clear is that Egypt is at least committed to the objective of resolving these disputes amicably. That's not going to happen in every case, and they won't succeed in every case. But nevertheless, it's bureaucratic, so it's not always going to work, but we can say that the state is adopting an active approach. It's not sitting back and taking a passive wait-and-see attitude, and that's been well received in the energy sector. There's no doubt about that. And there have been successes, not in energy, but it's worth mentioning briefly. If you look at last summer through to November, there were 3 high-profile ICSID treaty cases were settled. There was an ArcelorMittal case that was $650 million. There was the Bawabet al-Kuwait case, that was 420, and there was another claim by an Italian infrastructure company called ASA, and there's some others too. And it's worth reading a quote from the investment minister after the ArcelorMittal case was settled, which gives you a sense of the objective and the motivation. It was said the settlement emphasizes the Egyptian government's keenness to end all disputes with investors in a friendly manner so as to encourage them and give a boost to the investment climate in Egypt. Well, everyone can agree with this sentiment, but what you don't often see quite so readily in the region is something actually being done about that in an active way. So there's no question also that an overlay of very good news in the upstream in terms of exploration and development adds a positive sheen and makes everyone a lot happier at night. There's the brighter future of Egyptian gas, a slightly brighter slide as well. But the discovery of the Zohr field in the Mediterranean in 2015 has been incredibly important. It's topped up the gas resource by 1/3. Suddenly, it doesn't seem quite so appropriate to have such bitter struggles over domestic and export gas when you can take a more confident view of the future. There's been spin-off corporate activity from that. That was an Eni discovery that farmed out to BP and to Rosneft in the last 12 months. BP's made some very good discoveries in the West Nile Delta field offshore. So there's some very good news coming through that promotes further investment. There's a study by BNP Paribas, which has been well received, which suggests that because of all these discoveries, because of the investment that's coming in, there should be a reversal of the position which Egypt had slipped into a gas importing jurisdiction. The projection is that it will be self-sufficient by 2019 and subsequently should be exporting again. But it's also fair to say that that will only happen, that you'll only sustain export if new discoveries are developed properly, and that will take very significant investment. Of course, you need a stable investment climate, and the Egyptian government has got an eye on that, and this is part of the reason why you see things beginning to be approached in a very different and more positive way. But anyway, if there's one cloud, very briefly, I guess, about all of this particular good news is perhaps that there's a sense that the eye is being taken off the ball in terms of the renewables program, which was seen as the great next hope. Now that it looks as if gas is coming back very firmly into vogue, phase 2 of the renewables program is perhaps not being prioritized quite as it might. So that's a lot of good news, really. You might struggle with that slide at the back, I'm afraid. Those are the main strands of recent developments in Egyptian energy and energy arbitration and dispute resolution that I wanted to draw out. But when I think about dispute resolution in this sector in Egypt, when I think about the way in which the receivables issue has been managed in particular, I have in mind what was once described to me by a government official as the Egyptian genius for muddling along. It's a pragmatic approach of managing to keep going, managing to achieve results, even when the outlook looks impossible or it would depress lesser mortals, if you like. And I was put in mind of this on my last trip, looking out over Tahrir Square in the late afternoon. I suddenly noticed this absolutely kind of squeezed block of traffic, which was all so incredibly tightly bunched together. And you're thinking, how can that possibly work? How can everyone get around without, having even more collisions than you become used to when traveling in Cairo? But somehow or other, it does work, and somehow or other the Egyptian energy sector gets along as well and succeeds after a fashion through some very challenging times, some very significant disputes, even though, and I'm torturing the metaphor much to a greater extent than Steve here, but even though the participants are bumping and scraping along the way, but they still get along, or most do, most of the time, and that's Egyptian pragmatism for you. So, in terms of conclusions, here are the themes, and I think some of this could work and would work very well more broadly in the region. The government recognizes that investor disputes have an adverse impact, and they're taking active steps to avoid them, as we've seen. That is important. That's very important. The receivables issue undeniably remains very significant, but it's like a queue at the airport. If you can see it's moving, even if it's moving slowly, people don't get quite so anxious. If you think it's chaotic and people are coming in and nothing's moving at all, that's when people start to get very irritated, and there is progress being made. As to that, the SOEs and the Ministry of Energy value and very clearly prioritize long-term relationships. The investors who are in it for the long term and are prepared to still invest are at the front of the queue. There's no question about that. And in that sense, one hand doesn't clap alone. Upstream exploration success and a return to export is going to ease disputes, tensions, because when there's lots of upside to share, all concerned can be a little more generous in the way in which they treat others. But all that said, investing in the Egyptian energy industry, as most clients would testify, is still a very, very long-term horizon, albeit a generally optimistic one. So we finish again with another proverb and a suitably optimistic note, hopefully, for the rest of the conference. And it's an Egyptian proverb, as I understand it, so I'll give it the Egyptian pronunciation. Al-Gayat Assan min al-Rayat. So, that's another sweeping generalization, but what is coming is better than what has gone. I actually believe that's a reasonably accurate sense of the prevailing moods amongst the IOCs on the ground in Egypt, one or two notable exceptions. That may also be true of the rest of today's conference program from here on in, but nevertheless, I hope you found those observations on the Egyptian energy sector and dispute resolution of interest. Thank you very much. Thank you.